Hello everyone. So we were discussing part 6 of Indian Constitution, and as part of that discussion we already have delivered two chapters, that is chapter on governor and chapter on chief minister. So now we are entering into state legislature. So let us discuss that how we have planned to discuss this state legislature. So see, we already have declared that what we are following is parliamentary system at the central level and state level. So in response to whatever structure that we do have at the central level, similar structure we do have at the state level. So in response to the president at the central level, we do have governor. In response to the prime minister at the central level, what we do have is chief minister. In response to these two houses at the central level, that is Lok Sabha and Rajya Sabha, we do have legislative council and legislative assembly. So in response to Attorney General of India, we do have Advocate General. So in response to all the structure that we do have at central level, we do have similar structures at the state level. That is the point, because of the parliamentary system that we are following. So the approach for this particular chapter would be, see, as part of our discussion on the parliament, as part 5 of Indian Constitution, we already have discussed what is this Lok Sabha, what is this Rajya Sabha, what is the method of election that is followed in Lok Sabha and Rajya Sabha, first past post system, proportional representation system, right, the differences between those two, advantage and disadvantage. Then as part of presiding officer of both the houses, we already have discussed speaker's power, how speaker is appointed, how speaker is removed, then chairman, deputy chairman, legislative process, types of bill and privileges and immunities. So what we are going to, the approach that we will be taking for the state legislatures, as I already told you, that in response to the Lok Sabha we do have legislative assembly, in response to the Rajya Sabha we do have legislative council, in response to the presiding you have speaker at the central level for the Lok Sabha. Similarly we do have speaker and deputy speaker at the state level as well. You do have chairman and deputy chairman there in the Rajya Sabha. Similarly we also do have chairman and deputy chairman in the legislative council, and most of the time the powers that speaker has been given in relation to the Lok Sabha, the similar power has been given to the speaker in relation to assembly. So what we will do is that wherever there are common points, right, so when we will talk about the money bill, so money bill can be introduced only into the Lok Sabha at the central level, and similarly money bill can be introduced only in the assembly at the state level. So when we will discuss the parts of the speaker, when we will discuss the money bill, what treatment, what legislative process this money bill will follow, right. So there are common point at the central level and state level. What is the privileges and immunity that has been given to the MPs and MLA? So privileges and immunities that member of parliament does enjoy, similar privileges and immunity is enjoyed by member of legislative council and member of legislative assembly at the state level as well. So we will not discuss these privileges and immunities, and similarly wherever there is common point, there is commonalities, I will simply refer that you can refer, because on parliament we had spent enough time, around 10 to 11 hours. So there is no point of discussing all those common points here as well, right. You can simply, so the prerequisite for this chapter is going to be that unless you have this stronghold on the parliament chapter, parliament convention, the tools, how summon is issued, how houses are prorogued, what is means, unless you have clarity on those technical, what is this first past post system. So when I'll say that in assembly this first past post system is used, right, I'll not be explaining what is this first past post system, what is the advantage. I'll simply have a go by on these technical points. So again I'll urge you that if you have not watched parliament chapter where we had extensive discussion on 10 or 11 hours, right, you go watch parliament chapter and then you come here, right. So I hope the point would be clear to you that for the state legislature, parliament coverage is a prerequisite. You must have a strong hold on parliament. So that is the prerequisite. I hope you would have understood. Let us discuss that what is going to be the scope of this particular video. So in this video we will discuss both the houses at the state level, that is legislative council, LC we will pronounce it. So wherever in coming video, wherever you see these two letters LC and LA, so LA would be referring to legislative assembly, the short format, and LC would be referring to legislative council. I hope you would have understood. So legislative council is considered as upper house, almost equivalent to the, although there is slight difference between the parts. So when we will discuss the parts, we are not going to discuss in this video, but when we will discuss the parts of legislative council vis-a-vis Rajya Sabha, you will know that this legislative council is much weaker house vis-a-vis this Rajya Sabha. There is one more difference, that Rajya Sabha and Legislative Council, that needs to be stated outrightly here itself, and that one difference is that see, at the state level, having this Legislative Council is optional. Any state may have it, other states may not have it. So that is completely dependent on that particular state. But at the central level, this upper house, that is Rajya Sabha, the option has not been given to the parliament that, hey, parliament, do you want to have this Rajya Sabha? No. So at the central level, my point is that this Rajya Sabha, having this Rajya Sabha or not, that is not optional, that is obligatory on the parliament, that is obligatory on the central government. But having a legislative council is entirely optional, that is entirely depend on the state legislature, mind you, not the government but the state legislature, because for having this legislative council, the process when we will discuss, you will know that it is the state legislature which passes it with a special majority. So it is not the government's desire to have this legislative council at the state level or not. It is entirely dependent on the state legislature of that particular state, and thereafter this proposal will be forwarded to the parliament. So I hope this difference, one difference at least between legislative council and Rajya Sabha, you would have understood, although traditionally both the houses are called upper house, this Rajya Sabha at the central level and legislative council at the state level. I hope that difference you would have understood. This is legislative assembly, we will discuss in the details. So it is equivalent to the lower house at the central level, that is Lok Sabha. So this is not optional, legislative assembly, every state needs to have this legislative assembly. In third leg of this video, we will discuss qualification and disqualification norm for the members of state legislature. When I am saying state legislature, I am referring to both MLAs and MLCs. Right, MLAs are member of this legislative assembly and MLCs are member of this legislative council, member of MLC, member of legislative council and member of legislative assembly, MLA. So what is the qualification? If any person wants to contest for election either into legislative assembly or legislative, what qualification he needs to have, right? What age criteria, what citizenship criteria, is there any educational qualification, right? So what kind of criteria that we'll discuss, not rather discuss. See, the qualification norm that has been mentioned in Article 84 at the central level that we discussed. So if you remember, there are certain qualification for member of parliament that is mentioned in Article 84, and then you had this representation of People's Act, if you remember. So we had defined that there are certain norms that has been mentioned in the constitution. So he should be citizen of India, he should be of certain age, in case of LS he should be of this age, in case of RS, Rajya Sabha, he should be of this age, then he should be ready to take some oath. So those kind of qualification has been mentioned directly in the constitution. Thereafter a fourth option has been given, that parliament also does have power that they can regulate it. So in pursuance of that power, parliament enacted Representation of People's Act, and in Representation of People Act again there are certain qualifications. So similar, whatever we discussed for the member of parliament, similar qualification has been copy pasted in for this MLA and MLCs. There is one slight difference. So what I will do is that simply I will say that all the qualification that is required for member of parliament, those qualification will be applicable to MLAs and MLCs as well, but the difference I will point out, and that is going to be our approach when we will discuss the speaker, as I already told you, right? So wherever there is wide amount of similarity, I will not explain that, I will simply say that this has been explained already in parliamentary chapter. So I was referring that to have a grip on this state legislature, the prerequisite is parliament. I hope you would have understood, and in the last leg of this video we will discuss few, not discuss again, it is the 4 or 5 MCQ that has been put up. I'll expect you to attempt that. I hope that point would be, the scope at least for this video would be clear. This is the prerequisite, just a moment. So now we are entering into part 6 of Indian Constitution. So as part of our discussion on part 6, we already had discussed this chapter 1, but one thing that I forgot to point out, see, this is article 152, the first article in this chapter, part 6. As you can see, there are 6 chapters that has already been explained that what this 6th chapter consists of. So first chapter dealt with the general information regarding, and this one article, the very first article 152, defines what is state for this part 6 of Indian Constitution, and why it is necessary to define state for part 6 of Indian Constitution in very first article of part 6. It is necessary because if you remember, when we were dealing with part 3 of Indian Constitution, the very first article of part 3 was 12, article 12, and article 12 as well had defined state, that what is the definition of state, that is going to be part 3 of Indian Constitution. So that had been defined in very first article. Then you had this part 4 of Indian Constitution. Remember, the very first article of part 4 was article 36, and there as well it had been defined that what is the state. Now the definition of state that you had in article 12 and article 36 will vary from the definition of article 152. If you remember, again, while discussing this article 12, I had clearly stated that the the definition of state that we are defining in article 12 and article 36, their applicability will remain only to part 3 and part 4 of Indian Constitution. That definition that we had read regarding the state in article 12 and in article 36 will not be applicable outside this part 3 and part 4. Now in whatever definition that we are going to drive in article 152, that definition will remain alongside in whole of Indian polity, because whenever, means a traditional sense, if you say state, a general public will refer simply to, okay, state, we do have 28 states, Madhya Pradesh, Maharashtra, Haryana, Karnataka, Tamil Nadu. So that is the definition. The definition that has been defined here in part 3 and part 4 of Indian Constitution, that will remain at their applicability of state's definition will remain only to this particular part. I hope this difference, the first article, because this has not been, this I did not explain in the previous videos of governor and chief minister. That's why I thought of explaining it here, although it was not part of scope of this video, but because I had forgot to mention that, so I have explained. So this is about chapter 1. As part of chapter 2, we already have done governor in very detailed manner. As part of Council of Minister, there were 2 chapters, that is, one was dealing with CM, Chief Minister, and other with the conduct of houses. So that was dealing with the Council of Minister. So CM we already have done. Council of Minister will do at a later stage, rather Council of Minister as well as part of CM. Most of the information we already have discussed, but a separate discussion is necessary, and we'll have a discussion sometime later. As far as this Advocate General is concerned, when we will discuss this constitutional bodies, there we will discuss Advocate General, and in response to Advocate General, Attorney General of India is also pending when we were discussing part 5 of Indian Constitution. So Attorney General of India and Advocate General will be done all together when we will discuss the constitutional body. Now we are entering into this 3rd chapter that will deal with state legislature. So I hope the contours of this video or the scope you would have understood. Now we are moving to discuss this state legislature. So you have this article 166 which talks about what will consist of state legislature. So state legislature will consist of governor, then legislative council, that is upper house, and legislative assembly, that is lower house. If you remember, we had in similar structure we had regarding the parliament as well. So you had this article 79 here, which was talking about that what parliament will consist of. Then you had article 80, which was dealing with the Rajya Sabha, and then you had this article 81, which was dealing with Lok Sabha. So 79, 80 and 81, 3 continuous article. Here the only difference was that it was dealing with the parliament. So there should be a Parliament of India, that had been told in article 79, and what parliament will consist of, that had been described in this 79, that it will consist of president in article 53, then 81 and 80 and 81. So 3 continuous article, just presses. So similar structure we do have at the state level as part 6 of Indian Constitution. There it was part 5, now it is part 6 of Indian Constitution. So 3 article you can easily remember, 160, because that is in continuation Article 168, Article 169, Article 170, right? It is talking about state legislature, it is talking about the upper house, and it is talking about the lower house. The only addition is governor. One thing that needs to be pointed out, that governor is part of state legislature as well and state executive. Why he is part of state executive as well? Because if you remember, when we were discussing this article 154, we had clearly told that, rather not we, means constitution had clearly stated that all the executive power of the state shall be taken in the name of this governor, right? So he is part of executive as well, and this article 168 declares that he is part of legislature. Why he is part of, why he should be considered part of legislature as well? Because again, when what is the process of what is the legislative process? So legislative process is that legislative assembly passes the bill, it will go to the legislative council, or legislative council passes the bill, it will go to the legislative assembly. When both of these two houses has passed the bill, it will be sent to the governor. So in legislation, this person, governor, does have a primary role, and that's why he has also been considered part of legislature. So I hope these many things, at least structuring of state legislature, you will have now idea on. Now we are moving. So governor, see, we already have a separate chapter. So in this particular video, as part of state legislature, we are not going to have any study on this governor, that what is this governor, what are the powers he does hold, what is the discretion. We have wide amount of discussion in the previous chapter on that, so we are not dwelling. Here we will start with legislative council. As part of legislative council as well, why this body has been created, what is the objectives, I will not state, because similar, whatever the objectives were there for the creation of this Rajya Sabha, that it is a second house, it is a second chamber. It does, means Rajya Sabha does provide protection against hastily passed bills by the Rajya Sabha, where the government does have majority. So it can hold that bill for that, or it can send this bill for a reconsideration, right? Then it prevents the autocracy of this legislative assembly or Lok Sabha at the central level. So whatever discussion we had about the objective behind this creation of Rajya Sabha, similar objective you can copy paste into the legislative council. So the objective of legislative council creation will not get into, will directly delve into the basic information. So legislative, who can create this? As I already have told you, that this having this legislative council is entirely optional. Whether a state wants to have it or not, that is completely incumbent on the state legislature of that particular state. Now, who will create this legislative council? So ultimate power belongs to the parliament. Only parliament can create legislative council, but parliament suo motu will not create this legislative council. It is the state which will have to initiate that request. So state government or state legislature? So answer is state legislature, right? So whole of the assembly will sit together and they will pass resolution with this effect, that hey parliament, we want legislative council for our state, right? So what kind of majority state legislature does want? If they want to have this legislative council for that particular state, their particular state, so the majority that will be required by in the state legislature, that will be special majority, the majority that has been defined, special majority that has been defined in Article 368. But one thing needs to be pointed out, and that has not been put up in this slide. When we will get PDF, in that slide I'll make sure that you will have that information. It just came spontaneously in my mind, and that information is that although the special majority will be used by the state, but while creation of this legislative council, it will not be considered as amendment to the constitution under Article 366. Again I am repeating, because this slide does not have that information, that this creation of this legislative council will not be considered as constitutional amendment under Article 368, even though the special majority that state legislature is supposed to pass this resolution with, right? So that will require the special majority that has been defined in Article 368, but it will, creation of this legislative council will not be considered as constitutional amendment. I hope that point would be clear. So special majority is required by the state legislature when they are passing this resolution and requesting parliament to create legislative council for their particular state. But parliament, when it will reach to the parliament needs to pass that resolution, that request, only with the simple majority. So you need not to be confused. Again, I am pointing it out that special majority is required by the state legislature. State legislature, when they will pass the resolution, special majority, but in parliament, simple majority, right? So that is the first point regarding the legislative council. And when parliament does have power to create this legislative council, it can abolish the legislative council as well. But again, here as well, parliament cannot take a suo motu action. It cannot appropriate this power that we are going to abolish legislative council of a particular state, right? There are 6 states currently after demotion of J&K that does have legislative council. So parliament can't say that, oh, for the UP or for the Bihar or for the Maharashtra, we don't like कि भाई उनके पास legislative council हो. So that cannot be done, right? Again, on the state request itself, they will abolish that, right? So you have recently, means just in November 2019, if I am correct, right? In November, not November, I guess in September itself, in September 2019, Andhra Pradesh has requested to the parliament that they want their legislative council to be abolished. So Andhra Pradesh had requested in September. Now it is completely incumbent. Okay, one thing again that needs to be pointed out, when a state has requested for the creation of this legislative council, it is, means once proposal has been sent to the parliament, it is entirely on the parliament that what time they will take. So in the constitution, it has not been defined that within 6 months or within 1 year or within 2 years, this parliament needs to take an action or needs to entertain the resolution that has been sent by the particular state. So Rajasthan's example, if I take, Rajasthan had passed this resolution in 2012 and that is still pending with the parliament. Parliament is yet to take any decision, and because it is pending in Rajya Sabha, right, it has not lapsed even yet, right? So I hope that point regarding the creation, who does have power, what kind of majority, who can abolish this, right? So all those points would be clear. Second point, let me read it. After the state has passed resolution for creation of this LC, Legislative Council, parliament can virtually sit for such sit on this resolution, I guess. Sit on such resolution for eternity. No time mentioned in the constitution that in what time parliament should respond on that particular resolution. Parliament alone is empowered to abolish LC, but it requires a resolution passed by the state for doing so. Post demotion, you have 6 states in India currently that have legislative council. So prior to this 2019, before the state reorganization of J&K bill came, right, it was a bicameral, J&K was bicameral legislature, and until that time we used to have 7 states which had this legislative council. But with this, now this is UT, right, if you know, right. So in UT chapter as well we had discussed, and this UT one, J&K is with assembly and Ladakh is without assembly, right. So I hope, so right now currently you have these 6 states, 2 from northern India and 4 in the southern India. So Uttar Pradesh and Bihar, and Maharashtra, Karnataka, Telangana and Andhra Pradesh, 4 from the southern portion, right. Now there are 3 articles that deals with the legislative council: article 169, article 168, the first very article which was dealing with the state legislature. So in this very article it has been mentioned that there are 6 states that does have this bicameral legislature, and name of those states has also been mentioned in this article 168, right. So there are 3 articles that deals with the legislative council. One, article 168 itself, that deals with the state legislature. Then you have article 169 that deals with, and you have another article, article 171, that will have a discussion on, right. So that is dealing with the composition, that how many members this legislative council of different state, means once created how many members they can have. So the composition part, article 171 is dealing with. So there are 3, again I am repeating, 3 articles, 168, 169 and 171. when I talk about the term of legislative council, although this point has also I have raised in Rajya Sabha, there is no term for these houses. For Rajya Sabha, generally traditionally it is believed that Rajya Sabha term is 6 years, and similarly legislative council's term will also be 6 years, but that thing may be traditionally correct, but constitutionally it is incorrect, because in constitution it has never been mentioned that Rajya Sabha or legislative council will function for 6 years. It is their members term. 6 years is members term, right, not the term of that particular house. Legislative council and Rajya Sabha, right, that is a continuing house. The term of that particular, I hope you would have understood, the term that has been mentioned in the constitution, that is not for the Rajya Sabha or legislative council as a state, it is the term of their, means in constitution it has been mentioned, rather not even 6 years clearly. The only thing that has been mentioned that 1/3 of their members will retire every second year, that is the only thing, and from that 1/3 of members every second year, so from that we have deduced that the members term will be 6 years. So I hope that point would be clear to you. So term of legislative council, it is a continuing, it is not like legislative assembly or Lok Sabha at the central level, right, that can be dissolved every 5 years or even before. It is a continuing house like Rajya Sabha. So I hope that point also would be clear to you. Now we are moving to the next slide. If I talk about, so see, as I was telling, that the third article associated with this legislative council, besides article 168 and 169, that is article 171. Even if you cannot remember these article, no issues, right, just a broad idea you need to have, right. So I hope that point would be clear to you. So size of legislative council, so see, this size is not fixed. For different states the number can be different, right, but that number must follow this rule, and the rule is that the number of members that a legislative council of a particular state will have, that will vary between 40 to 1/3. 1/3 of what? 1/3 of total size of, oh sorry, again a content mistake, and that is 1/3 of legislative assembly. So whatever size that legislative assembly of that particular state is, the maximum size of their legislative council can be 1/3 of their assembly size. Let us take an example. So as I already told you that in 2012 you had this Rajasthan which had requested for the creation of legislative council. Now if you remember, the size of Rajasthan assembly I guess is 200, right. So the maximum, see, the minimum they will have when, if parliament approves, as and when they approves, right, the minimum size the legislative council can have is 40, that will be the minimum size, and the maximum will vary 1/3 of this 200, that is the size of legislative assembly. So 1/3 of total size of legislative assembly. So from 40 to 67, right, because 67 is 1/3 of 200, right. So they can have, their legislative council can have members anywhere starting from 40 to 67. So they can have 50, they can have 55, they can have 67, they can have 40, right. So they cannot have lower than 40 and they cannot have more than 67. So that is the point that it is talking about, and that has been mentioned in article 171. So size of legislative council can vary from 40 to 1/3 of size of legislative council. House consists of both elected and nominated members. We will see that, right. So there are some members, rather most of the members are elected, but again that election is not on FTP, first past post system, and that is not a universal adult franchise where each and every citizen is allowed, rather each and every, not citizen, every voter is allowed. They are not allowed. There is limited electorate. We will discuss that who are the people, what group of, what class of people that get into the election, that forms part of electorate. We will discuss that, right. So both elected, they consist of both, the members comes from both election and nomination process. As of now, just remember this. As far as election is concerned, election method that is used is not just a moment. So the election method is not first past the post system that we used in general election and for the assembly election. right? The method that is used is proportional representation by single transferable. Again, you should not expect me to explain again in this video that what is this proportional representation by single transferable method, because this again has been explained in the presidential chapter, and we had taken around half an hour on the discussion on the merits and demerits that this FPTP has, the advantage that this proportional representation does have, what is the single transferable vote, what advantage it carries along with, right? So we had all the discussion, what is the difference between first past post and this system of election, right? So proportional wherever this election is used for election of the members in the legislative council, that election method will be proportional representation by, similar that is used for the election of Rajya Sabha members, for vice president and president, right? So that is the same kind of election method. Third point, members to be nominated by, or rather before discussing this third point, let us discuss that we already have declared that there are some members that will come by the method of election, and then there are some people that will come by nomination. So how many members will come through this nomination and how many members will come through election? Let us discuss this, right? So whatever legislative assembly, legislative council size has been discussed, right? So out of that size, so suppose if I am taking example of Maharashtra, so Maharashtra legislative council size is 78. So out of that 78, 1/3 of the members will be elected by the legislative assembly members. So 1/3, whatever 1/3 of this 78 will be, right? 1/3 of 78, that will I guess translate into 26, right? So that 26 members will come from this legislative, means they will be elected by members of legislative assembly by using this method of proportional representation by single transferable vote, right? So that is how 1/3 member will come from. Another 1/3 will come from method of election, and those election, that for that another 1/3 election will be participated by members of municipal, members of district board, that is a Panchayati Raj institution created by 73rd, and this was created by your 74th amendment, right? So by members of municipalities, by members of district board and such local authorities at the state level. So 2/3 people has been elected, 1/3 by members of legislative assembly, 1/3 by this member of municipalities and district board and other local authorities. So 2/3 member has been elected. Another 1/12 member will be elected by graduates of that particular state. All the see, there are complex criteria that which all graduates will be included. There are like those holding 3 years degree from last 3 years, so that kind of criteria, but we are not getting into nitty-gritty. So for simplicity, just I have put it by graduates of that particular state. Again, there is a rider that not all graduates get to elect into. There is some complex procedure that I am not getting into, right? So 1/12 will be elected by, again in every election the method of election will be proportional representation by single transferable vote, right? And that is what I was talking about, that franchise is very limited. So for 1/3 election, it is the legislative assembly members only participated. For another 1/3, it is the municipalities member who has been elected in these municipalities and district board and other local bodies at the state level. Then 1/12 of this 78 member is being elected by the graduates, and another 1/12, right? So collectively it will translate into 1/6, these two if I conclude. So another 1/12 will be elected by teachers that are teaching above secondary and upper level. So it can't be that teachers teaching at primary level, but the only eligibility criteria for those teachers is that they should be teaching in schools that is at the upper secondary level, secondary level and upper secondary level, right? So that is one. So 1/12 by graduates, 1/12 by these kind of teachers. So 1/12 if you combine 1/6, it will translate into, so 1/3 plus 1/3 plus 1/6, I have combined these two, 1/6 has been elected, right? So the pending members are 1/6. So the remainder will be elected by, nominated by. So here all these 4 classes, all these rather 5 classes had election, right? So 5/6 members come by the method of this limited election, right? Proportional representation, single transferable vote. The pending 1/6 of the member will be coming into the, or will be entering into this legislative council by process of nomination. Nomination, who will nominate? Governor. Will governor exercise his discretionary power while nominating? So the answer can't be given in binaries, that yes or no, because traditionally governors has accepted the recommendation. What has been tradition in past 72 to 73 years, that traditionally governors have followed the advice or the spirit that has been mentioned in article 163, that guides governor to work from the aid and advice of chief minister. But there has been times where governor has not abidden by the suggestions of chief minister or council of minister. They have deviated and they have taken independent decision while nominating members into the legislative council as well. So we'll have a discussion on that as well. There is one separate slide that is reserved for that discussion. So as of now, see, and in constitution, in the article 171, this has not been mentioned that 1/6 of the member will be nominated by the governor. The word that has been mentioned in the constitution, that is remainder of the member. After having these members, after locating that, okay, what will be the 1/3 of 78, right? What will be the 1/3 of 78? What will be the 1/12 of 78? So what you will have is, in every, when you are calculating 1/3, right, numbers will not always be like 28, 29. That will be not natural numbers. What you will might get is 28.75, because you have to divide, right? You might get is 26.15, right? So you will not take, means persons can be cut into pieces. So what you will do is that whenever any number crosses beyond 0.5, you will round figure it by 29 or 30, right? So whatever remainder number that governor will get, right? So in case of Maharashtra, I told you that the size of legislative council is 78. So if I go by the calculation that 1/6 number governors would get to nominate, so it will translate into 13 members. But the governors in Maharashtra, especially in context of Maharashtra, if I talk about, governor does have power to nominate only 12 members. So why this differentiation when the calculation is coming into 13 while in real time it is in 12? So it is because of this 1/12, because the result of 1/12, 1/6 or 1/3 of a natural number will always not be a natural number. What you will get is in fractions, 2.28 or 26 point something, right? So that is the point. So the word that has been used in constitution is not 1/6 but remainder. So remainder of the members will. So I hope that point you will have understood that why I had used that word, that some member will come from through election, limited election, and some members will come from nomination. So these people are coming by election. 5th, 5th, 6th of the members are coming through process of election, and 1/6 are coming, means again when I am saying 1/6, I am being cautious of the fact that in constitution the word has been used remainder. Again, members to be nominated by governor shall consist of. So in what category? If you remember, when president was nominating 12 members in Rajya Sabha, so there was some category in which people should belong to, only then those people will be nominated by the president. So here as well at the similar level, right, you have people belonging to the literature, you have people belonging to the art, you have people belonging to the science, you have, there are two additional sectors, that is domain rather, that is cooperative movement if any person has belonged to, and social service. So people who are being nominated by the governor should fall into this category. But again, there have been cases where people have not belonged to this particular category. There is one more word that has been added in article 171, and that is that he should have that special knowledge and practical experience. So most of the time politicians are nominated in these seats as well for this 1/6 of the seat, although the spirit was that the people who belong to the literature, who belong to this field of science and art, then they can have contribution, but that is being spoiled by including professional politician, that we'll have a discussion on professional politician, and they are said to belong to this, that they do have a special knowledge and practical experience in field of politics, and that that's why on these grounds they are nominated by the governor. So I hope this point you would have clarity on. Now we are moving and discussing this question we already have raised, that governor's power of nomination in LC, Legislative Council, is that a discretionary power? There is a kind of doubt, because at many instances there have been cases, but that the case has landed into the High Court, and different High Court, 2 or 3 High Court has given the stance that no, this power is not discretionary. Governor need to abide by the spirit that has been mentioned in Article 163, that he needs to follow the advice of Council of Minister while nominating members into the Legislative Council. But again, there have been instances in I'll take this example, I'm just explaining you the general terms. So there has been instances where High Court itself has said that no, this is the power of governor and he can exercise that power in a discretionary manner. So there is absence of convincing judgment from the Supreme Court which can forcefully say, and it is this area again means. So my take on this governor's discretionary power, because governor's discretionary power has a wide amplitude and wide latitude that he can exercise this discretionary power in, right? So there should be, rather than having Supreme Court and High Court giving its judgment and trying to have it a force of law, their judgment having force of law, rather constitution should be relevant, articles should be amended, and his power should be clearly defined. Because at times they have, means why I have raised this question, it has a recent context, and the context is this, that recently, and this point we had discussed in governor chapter in detail. So recently you have this case of Maharashtra Chief Minister where he had to enter, he was not a member of Legislative Assembly, and he had to get get as a state legislature member, either MLC and MLA, right, either within the 6 months. So Council of Ministers sent the advice to the governor that, hey governor, can you nominate this person into the Legislative Council by exercising powers that has been given to you. But governor kept delaying this issue until this matter was solved at the political level, until this person dialed his political opponent at the central level. This matter was not resolved, and it was only after much needed intervention by the Prime Minister itself, right, only when center directed the governor. Again, this is not an official position that you can write in your answer sheet, but unofficially I am letting you know that it was only after the central direction that governor nominated this person, right? And it is in this context that this question should be raised, that whether this power of governor is discretionary or not. As I already told you that the answer can't be given in binaries. This answer is reserved into these decisions of the High Court, and as I again told you that in absence of convincing judgment from the Supreme Court, this power remains open for use and abuse depending on the situation that governor is have, right? So in 1952, and the abuse of this particular power, the debate whether this power is discretionary or not started immediately after the independence. So you had in 1952 C. Rajgopalachari, right? He was popular leader of Congress. So C. Rajgopalachari, who was not even MLA in Tamil Nadu, and he was to be made Chief Minister, right? Chief Minister was somebody else, and when he was to be appointed Chief Minister, and it is necessary that he should be MLA or MLC, he should be part of legislature, state legislature within 6 months. So governor here, without following the advice of Council of Ministers, without even asking Council of Ministers whether this person should be nominated into the Legislative Council or not, what he did is, governor at that particular time of Madras state, what they did is that he nominated C. Rajgopalachari in the Legislative Council without following, and there was wide amount of again political tussle that happened on that particular issue. But again, the CM at that time belonged to the Congress itself, so ओके पॉलिटिकल लेवल पे उसे स्पेसिफाई किया गया. अपोजिशन ने इस केस को चैलेंज किया था मद्रास हाई कोर्ट ने, बट मद्रास हाई कोर्ट फाइनली रिफ्यूज टू एंटरटेन इवन, मींस दे डिड नॉट सी any merit that whether this power should be, whether a decision should be taken in this regard or not. I hope that point would be clear to you. In 1964, again 4 Congress backed persons were appointed, and they were political, were appointed in UP Legislative Council by the governor. Again, the advice of Council of Minister was not taken into the account. Again, in Allahabad court against this decision of the governor, case was filed, but in Allahabad High Court in that particular year said that no, this is a discretionary power of the governor. So there are 2 cases which says that this power of the governor is discretionary, but in these 2 cases in 1964 and 2012, that is a recent case where Andhra Pradesh High Court has said that no, this is not a discretionary power. Governor, while exercising this power, must take care the guideline that has been mentioned in Article 163, and he should act with the aid and advice of this power, with aid and advice of Council of Ministers. So I hope, so again, that I was saying that in absence, there are various high courts which are saying that no, this power is discretionary. There are few high courts which are saying that no, this power is not discretionary, he should follow the advice that has been extended in Article 163. So there has been a lack of consistency in the decisions of the High Court, and Supreme Court forcefully has not done anything in that regard. So in that in circumstances like that, where you do not have a convincing judgment, this power remains open for use and abuse, and governors have time and again delayed. So again, even if High Court has given the decision in 2012 that this is not a discretionary power, they forgot to mention that in what time, if Council of Minister has extended this advice that hey, can you appoint these 2 people or 4 people using your nomination power, so governor can virtually sit, again I will use that word, eternity. So prior to request of this Uddhav Thackeray by the Council of Minister to governor for the nomination of Uddhav Thackeray, NCP had given request, means even prior to this, and on that decision governor took no decision. So they can virtually sit for eternity on the suggestion of Council of Minister, because there is lack of clear-cut power that has been defined for the governor, and that's why I was saying that these things, rather than having these decisions coming from High Courts and Supreme Court, Parliament itself should take the cognizance and they should go for the constitutional amendment, and his power should be clearly defined, because we have often seen that there have been committees and commissions, Sarkaria Commission, Rajmanar Commission, which has commented that this arbitrary exercise of power, his term, his appointment method, then his discretionary power, that should be clearly defined, that in what areas, rather than giving him situational discretion, it should be clearly defined that in what all situation he can exercise his discretionary power. So I hope the point you would have understood. Again, these kind of questions won't be asked, confusing question where there is chances of subjective interpretation, those kind of questions won't be asked into the prelim. I hope that point would be clear now. And here on this particular slide, I am just going to provoke your thoughts. These questions that I'll raise on this particular slide, I am not going to respond. I'll just set the tone for that discussion. You have to, means whenever you do have time, you have to think over these points, right? So this will help you in mains answer writing. So nomination of unpopular politician, is that not subversion of democratic process? Let me explain you, let me put up in simple matter. So suppose there is one person, one politician who was into previous government. So suppose if I take example of Bihar again. So Bihar is going through election right now, and there is suppose one minister or MLA against whom there is wide allegation of corruption. So he has been indulged into the corruption, although cases has not been proven into the court. So he went into the new election in 2020 and sought the election from the people. People voted out, people did not vote for him, and he was defeated from the constituency he was contesting in. And just because this person who was defeated by the people, just because he happened to be blue-eyed boy of chief minister, next chief minister, whosoever is going to form the government, just because he is very lovely to that chief minister, what chief minister can do is that chief minister can ask governor that, hey governor, he has been defeated, no issues, but can you nominate this person into the legislative council so that I could have this person in my council. Now, how appropriate it is that when people in the we are a democratic country, aren't we? So, in a democratic process, when a person has been discarded by the people, he was not, of course, people's choice, because had it been people's choice, he would have been elected, right? So, just when people has already discarded, what right CM, and again, technically I am not talking about, constitutionally I am not talking about, I am talking on ethical grounds, right? So, what right this chief minister or the governor does have, that he is appointing, he is nominating this defeated person who had participated in to the direct democratic process. When he was defeated, he is now again being introduced by the backdoor method, right, just to have a seat in Council of Ministers. So, there is no value of people's choices, right? That is what means, indirectly, that is what means our constitution is telling, or the peoples or the politicians are telling, right? So, in that direction, you had this again, I should not be taking names of departed souls. So, you had this late ex-finance minister, I should not name him. So, he was finance minister from 2014 to 2018, later because of his ill health, this finance ministry charge was given to the Piyush Goyal. So, he had fought a contested election from Amritsar seat into the 2014 through the Lok Sabha. He was defeated. Now, again he was brought using that Rajya Sabha method, and he was made finance minister. So, that is what blue-eyed boy I was talking about. So, these kind of question I have raised on this slide, that should a electorally defeated person be given backdoor entry through route of nomination? Is this not fraud on people's choices, or is this not fraud on constitutional principle? Should a previous minister allegedly involved in corruption cases, voted out by the people in direct election, should he be allowed to enter into the next government using this nomination route? The Council of Ministers, again I was talking about, where person who has been democratically voted out, he is being nominated into the Legislative Council at the central level, state level, and by in the Rajya Sabha at the central level, just because he could become part of this Council of Ministers. So, how appropriate it is. However, in absence of convincing judgment, this is the point actually I should have. However, in absence of convincing, this power remains open for use and abuse. Governors have time and again. This is actually a strip from the previous slide. So, I hope these two questions you would have understood, and you would ponder over these 2 points. Now, we are moving to the next point. So, effectiveness and utility of Legislative Council. So, effectiveness and Legislative Council, you will have much clarity on when we will discuss the legislative process. So, you will see few of the weaknesses of Legislative Council, how powerless this Legislative Council, and when I am saying powerless, I am talking in relative terms, that how powerless it is with respect to the Rajya Sabha. At the central level, Rajya Sabha is much powerful house. It does have almost, this Rajya Sabha does have almost equivalent power to the legislative, Lok Sabha, except in cases of money bill and F1 financial 1 bill. Even in this financial 1 bill, right, once it has been introduced and sent by the Lok Sabha, it almost I am saying equivalent power. So, Rajya Sabha at the central level enjoy almost equivalent power, but that is not the case to this Legislative Council, and that's why I am raising this question, that what is the effectiveness and utility of this Legislative Council. So, even before understanding the effectiveness or utility of any house, you will have to understand the objective, that what was the objective behind creation, and whether that particular house is fulfilling that goal or objective or not. So, objective were these, and this objective we already have read, that into the Rajya Sabha, behind why Rajya Sabha was created and what is the objective of Rajya Sabha. So, to check hastily passed bill into the assembly, to prevent autocracy of the assembly, you can simply, means when you will deal with the Rajya Sabha objective, you can replace this word assembly with the Lok Sabha, to accommodate people of talent from science, from arts, from social background, right, and to introduce people who can't enter assembly. See, election is going to be very costly affair. So, although constitutionally, again, in Representation of People's Act, the limit that has been defined is 28 lakhs For election of MLA, so that is the amount that an individual person can do, 28 lakhs if he is contesting, and 70 lakh for the election of member of parliament. So this is the amount that has been allowed by the Representation of People Act, that a person who is contesting for MPs and MLA can spend during his entire campaign. But the election, if you see at for the MPs, right, where there has been various news publication where it has been cited that there have been constituency where the amount spent by each candidate has been, or rather top 4 or top 3 candidate has been in tune of CRs, 60-70 CRs, and the normal average is somewhere 15 to 20 crore. So my point is that this elections method, either at assembly level or general election for the Lok Sabha, right, elections are costly affair, and for people belonging to our class, that is middle and upper middle class, it is not at all possible to enter into the politics and get elected either into the assembly when so much muscle power and so much this money power is to go into the election. It is almost impossible. So it was means my take again on having this legislative council and Rajya Sabha would be that it was, means constitutional fathers would have ideated that it is for these kind of people that should be allowed into, who do have this academic excellence, who are very scholarly people, who have written these research paper on politics, on governance, right. So those kind of people should be given place in this Rajya Sabha and Lok Sabha through process of nomination and through process of election. But what is happening here is that, leave alone those election method, even through nomination, whatever power that president does have to nominate into the Rajya Sabha, or whatever power that governor does have in for this legislative council, for the people belonging to the science, for people belonging to the art, for people belonging to the literature, social sciences, special knowledge. So even in those area, professional politician. So objective or effectiveness is, and if you compare again the power that legislative council has been given, right. So taking all those points into the account, you will realize that legislative council is not completely, that would be a strong word, but to many extent it has not been able to fulfill the goal or the objective that was envisioned in the constitution, right. So but members in legislative council are elected, nominated on the political lines. So most of the members, that means I was already pointing out that the members into the legislative council should have been belonging to those particular category from the social science. But right now that you can see is that even nominated members are being introduced from on the political lines. Those people who do have political backing, only those people can think of getting into the legislative council and Rajya Sabha, right. So the members in legislative council are elected, nominated on the political line on the basis of political clout that they have. Even nominated seats are being awarded to the professional politician, and it is this background, it is in this context that we will say that legislative council is not at all, or not to the extent that it was envisioned by the constitution. So it is not effective to that extent. It is drain on, it has been criticized as having drain on the resources of the state, on the resources of the people. Then it is a weak house when we'll see the parts of legislative council vis-a-vis Rajya Sabha, vis-a-vis state legislative assembly. We'll see that how this is a weak house. It is a delaying house simply, right, because in absence of power that has been given, little amount of power that has been given to the legislative council, it is called a delaying house, that it can at most delay the bill for 4 months. What is this concept of 4 months? We will discuss that as well. It is not a second house. So unlike Rajya Sabha, which is second chambers in parallel to the Lok Sabha, legislative council is not a second house, it is a secondary house. We will understand that as well when we will have a discussion on the power. It is for the backdoor entry of aged person, for retired person, who are politically retired, right. For a particular party, if he is retired, he is not productive electorally, not productive I am saying from any other point, from intelligence or from other point, I am talking in terms of electoral. So if there is any person who has served a particular party for 70 years, for 50 years, right, and if he or she has reached to the age where he is not electorally beneficial for that particular party, he is given a seat in legislative council कि भाई आप उधर settle हो जाओ, right? So retired defeated politicians, so it gives place to these kind of people who are defeated, who are aged, who are retired, right, on the political line. So this has been the criticism of legislative council. I hope these points you would have understood. One more area where you can see the ineffectiveness of legislative council, that is, if you remember, under article 312 and article 249, when we were discussing Rajya Sabha, we had said that there are certain special power in addition to the power that Lok Sabha does have. There are some additional very powerful power that has been given for to this Rajya Sabha under article 312, wherein Rajya Sabha alone can initiate the resolution for the creation of new all India services, and when matters on the state subjects is to be legislature, it is the Rajya Sabha that does have that power, but no such parallel power has been given to the legislative council. So from this point as well, you can gauge that how ineffective the legislative council does have at the state level. But again, I should not be getting completely into the criticisms only, right? To some extent, whatever objective that has been mentioned, right, it is not at all completely failed, right? To some extent, it is fulfilling the goal, but not to the extent that was envisioned in the constitution, right? So it is not that it has entirely failed on this point, it is not that it has entirely failed, or although it does have weak powers, but to some extent, right, it does control this hastily passed bill, right? To some extent, it prevents autocracy of the assembly, right? So completely taking a strong point while criticizing this legislative council because of the weak powers that it does have would not be appropriate. So I hope that point you would have understood. Now we are entering into this legislative assembly, so lower house at the state level. So you have this article 170 which talks about legislative assembly in the state, and the size of legislative assembly in different state can vary from 60 to 500. So the maximum size of any legislative assembly can be 500 and the minimum size can be 60, right? Although as far as minimum size of legislative assembly is concerned, there are certain 4 or 5 state, rather 5 state, right? States like Goa, states like Sikkim, states like Arunachal Pradesh. So there are 5 states which does not follow this rule of 60 to 500, right? So these are 5 states. Just a moment, let me show you, just a moment, on the map itself. So these are the 5 states that you can see. So you have this Goa on the western coast, then you have Sikkim, which were admitted into India 1975, there are Arunachal, Nagaland and Mizoram. So these are the 5 states which does not follow this minimum and maximum rule. It does have, because of smaller population that these 5 states does have, right, their size, for some it is 40. There are 3 states out of that 5, right? There are 3 states which does have 40, then 46, and one does have 32 as well, right? So this is the normal guideline that has been mentioned in the article 170, that this should be the number of the assembly in various states, but these 5 states does not follow that rule. If I talk about the maximum number of seats, so the UP, there are, although Lakshmikant does have this long list with each state having what assembly seat each state does have, but again that is not humanly possible to remember all those seats, all those states, and neither desirable as well. So what I have done is that I have taken 3 or 4 states which does have most number of assembly seats. So UP holds 403 and it is the largest assembly that Indian state does have. So 403 seats. Then you have West Bengal, thereafter you have Bihar, and then Maharashtra, which have 288, and then Bihar 243. These are 3 smallest states, 40, 40 and 32, right? This is, although the smallest number of seat is being held, assembly seat is being held by Puducherry, but that is not a state, that is UT with assembly. So I hope you will have an idea on the method that is used into the election of these people for the assembly. That method is direct election, not the nomination, and indirect election as well, first past post system, not the proportional representation through single transferable method. Universal adult franchise In this direct election, every eligible voter can participate into the voting. Concept of territorial, it is similar like that is used in the Lok Sabha, so I need not to explain this. I hope you know already that what is this territorial constituency. Term of assembly, generally it is said 5 years, but it can be increased and decreased as well. So if in a politically frugal state, if any party cannot manage the numbers, cannot have the majority, the House state legislature can be dissolved prior to this 5 years as well. The tenure of state legislature can be increased as well. So if there is imposition of national emergency under Article 352, so in that circumstances, if national emergency is to continuing beyond a period, and wherein in between if state legislature's term is expiring and it is not possible to hold the election by the ECI, Election Commission of India, because of certain perilous situation, though, so in that circumstance you will see that there is provision in the constitution itself that the term can be increased, the tenure of legislative assembly can be increased. So I hope that point would be clear, that it is not fixed. As far as reservation at the political level for the election is concerned, on the basis of population for SC/ST brothers and Anglo-Indians, rather this Anglo-Indian concept has been finished, nomination of this Anglo-Indian. So there was provision in the constitution that in Lok Sabha there was provision that 2 Anglo-Indian could be nominated by the president if in president's opinion, if there has not been enough representation in Lok Sabha for this Anglo-Indian community, so 2 people could be nominated. And in assembly as well, governor does have power that he can nominate 1 member from this Anglo-Indian community if in opinion of governor this community does not have adequate representation in assembly through the election, right. So, but that option has been abolished by 104th Amendment Act, where governors, this power of governor and the president power at the central level has been done away with. So that was about Anglo-Indian, that has been mentioned in Article 333, and that's why I have put up this strike through, that no longer this Anglo-Indian concept for assembly nomination is applicable. As far as Article 330, which talks about political representation for SC and ST community at the assembly, as the Lok Sabha as well, we talked there as well, that in under Article 330 there are 84 seats that are reserved for SC/ST community, right. So there we had talked there, but at assembly level as well, depending on the proportion of population, right, seats are reserved for SC and ST community. That has been mentioned in Article 330. Article 333 provision has been done away with. That was what is this Article 334? So Article 334, see, the difference between Article 330 and Article 334 is that Article 330 talks about provision of reservation, and Article 334 talks about that how long that reservation will last. So before this 104th Amendment Act in 2020, I guess, right. So before this provision of 104th Amendment, right, that was brought by the government and passed by the Parliament, right, this provision of reservation for these 2 communities, SC and ST community, was to last until 2020, but by this 104th Amendment Act, this provision of political representation in the Lok Sabha, for the election in Lok Sabha and assembly, has been increased until 2030, right. So that is what this Article 334 talks about, ki kab tak, till when this political reservation will last. So I hope that point would be clear to you. Now the question that you can ask is that just because in Article 330 it has been mentioned that seat shall be reserved for SC/ST community, is it necessary or is it mandatory for every state to reserve the any constituency at the political level for the election? No, that is not the answer. See, it is talking about the proportionate representation. So if there is any state whose any constituency does not have significant population from these 2 community, from SC and ST brothers, then that state need not to reserve that seat. So you have these seats, states like Arunachal Pradesh, Punjab, Meghalaya, Mizoram, Nagaland, which does not have any seat reserved for SC communities, because they do not have any constituency which does have, collectively I am talking about, any constituency. At the state level it may be that okay, 4% of the people or 5% of the people may be belonging from this particular community, but a particular, when I am talking at the constituency level, there might be that at constituency level no constituency, not even a single constituency will have sizable population, and that's why you have these state which does not have any reservation for SC community. Then there are certain states like Goa, Punjab, UP where they do not have significant tribal population, and similarly they do not have any seat reserved for these ST tribal brothers. So I hope that point would be clear. Again, the Lakshmikant does have huge list that which particular state has reserved how many seats for SC community and which state has reserved how many seats for ST community. Again, that is not humanly possible, neither desirable as well. What you can do is that you can remember that which all state does not have any seat, any representation, any political reservation for SC community and ST community. So that is the list here, and which 2 or 3 state you can remember that which state does have most number of seats reserved for SC and ST. So as far as tribal population in Mizoram, Arunachal Pradesh and Meghalaya is concerned, they do have huge tribal population, and these state, if I talk about Mizoram does have these 3 states does have 60, size of assembly is 60, and out of 60 if you see 59 seats are reserved for the tribal population. Again 59 in Arunachal as well has been reserved for tribal people, and 55 in Meghalaya seats, right, Garo, Khasi, Jaintia. So tribal population, these states are dominated by the tribal population, and that's why most of the seats are, not most, almost every seat except 1 seat here, except 1 seat here, and except 5 seats here, almost all the seats are reserved for tribal communities. Similarly, UP does have most number of seats that is reserved for SC communities, 85 seats out of 403 seats. Then you have West Bengal, 68 seats out of 294 seats. Then you have next Bihar, 38 seats out of 243 assembly size that they do have, right. So I hope the reservation concept at the political level, and mind you again this reservation that we read under article 330 and 334, this is different from the reservation that people do get at the social level in educational sector and the job sector. So I hope that point would be clear to you. Now we are moving to next slide. So this is the special power of the assembly, and this is special power of assembly is again nothing. If you remember, the Lok Sabha also did have some special power that no confidence motion can be moved only into the Lok Sabha, money power can be money bill can be introduced only in the Lok Sabha, money bill can be certified only by the head of the Lok Sabha, that is speaker, she only can certify. So all those special powers are available to the assembly as well. So at the state level, so let me now discuss this, right. COM is responsible, although to whole of the legislature. At the central level, COM, Council of Ministers, although generally he was responsible to whole of parliament, but specifically he was this Council of Ministers was responsible only to the Lok Sabha. Similarly here at the state level as well, Council of Ministers although is responsible, he will have to go if legislative council members are seeking any kind of question from agriculture minister, from educational minister, that minister will have to go into the legislative council as well. But as far as ultimate responsibility is concerned, he is his ultimate responsible to this legislative assembly alone. So that point would be clear, and these 3 points are very simple, that money bill can be introduced only in legislative assembly, it is certified as a money bill, any bill is certified as money bill by the assembly speaker, then no confidence motion only, right. So all those points are almost similar, so let me not discuss those points. As far as see the qualification for us, so if any person is seeking election, if any person like you or me want to get into election, so I'll have to file the nomination, I'll have to go through the nomination. So even to file the nomination, even to contest the election as a MLA, there are certain qualification that has been mentioned in the constitution, and there are certain qualification that has been mentioned in Representation of People Act 1951, right. So we need to have those kind of qualification, and all these qualification we already have studied in the Parliament chapter. So under Article 84, if any person wants to contest for Lok Sabha, or if any person contest for the Rajya Sabha, he needs to have these kind of qualification. Just the only difference for the MLA, the only difference is of this article number 1, right? So that is the one difference. And the second difference, there are two differences. So one difference, that Article 84 it has been discussed in, and the second difference is that in RPA, Representation of People Act, one qualification is that if any person want to contest for Member of Parliament for the Lok Sabha and Rajya Sabha, he should be registered as voter in any part of India, right? Does not matter. So if I want to contest from election from Bihar Lok Sabha seat, and does not matter whether I am a voter in Haryana or Maharashtra, it will not matter at the central level for the Lok Sabha. But if I want to contest election in Haryana as a for the MLA seat, then I need to be a registered voter in Haryana itself, the state in which I want to contest election for MLA seat or MLC seat. I need to be registered in that particular state as a voter. I should not have taken birth in that particular state, but if I am registered as a voter in that particular state, only then I can contest the election for MLA and MLC, right? So that is an obvious thing, right? So registered as voter, just a moment, registered as voter in concerned state. So that is the only difference. Otherwise, all the qualification that was required for a person to contest election as Member of Parliament, the same qualification he or she needs to have, right? One pointer that I would like to, that there are certain qualification for a person to contest election as MLA that has been mentioned directly into the what you call constitution, and there are certain qualification that has been mentioned in Representation of People's Act, in a statute, not in the constitution. So these qualifications, you need to have a separate eye on this, that these qualification has been mentioned in the act and these qualification has been mentioned in the constitution. And this pointer I had raised in the Parliament chapter as well, that if a question is framed that and in that question, if there is an option that this person needs to be registered voter in that particular state, that has been said in constitution? No, it has been said in Representation of People Act. And why this Representation of People's Act 1951 was created by Parliament? Because Parliament has been empowered by the constitution to have any such act whereby it can regulate the election process. I hope this difference would be clear. Why I am not discussing all these points? Because these points has already been discussed. Now on the next slide, let us discuss this disqualification norm. Again, this disqualification norm, again I will not discuss, because this under Article 102, the disqualification norm that is applicable for Member of Parliament, the similar disqualification norm a person or a MLA will also be subjected to. So if a MLA is falling into any of these category, if he is violating any of these norms, and if he is not falling on any of these norms that has been mentioned here, MLA will be disqualified, and that has been mentioned at two places in Article 191. Article 102 was the disqualification norm for Member of Parliament, that is Rajya Sabha members and Lok Sabha member. The difference here is Article 191. So just article has been changed, right? For MLA and MLC, article has been changed, right? The disqualification, if a question is asked that where is the disqualification norm mentioned for the state legislature, so there are two places. One, there are set of norm that has been mentioned in Article 199, that is directly into the constitution, and there are set of norms that has been mentioned in Representation of People Act 1951, right? Again I am saying that I am not discussing it because this point has already been discussed in the Parliament. So with this we are wrapping up this lecture, and who will take the decision whether a member of Legislative Assembly and member of Legislative Council whether has been subjected to the disqualification norm or not? So that decision will be taken ultimately by Governor in consultation with the Election Commission of India. Final decision will be of Governor, but he needs to have opinion of Election Commission of India. At the central level, if I talk about, right? So president will take decision whether a particular member has fallen into this category, and he should be subjected to the disqualification parameters or not. So that decision will be taken by president at the central level in consultation again with the same body, that is ECI. So here we are wrapping up this lecture. We had enough discussion, right? So there are few questions that I expect you to attempt. So this is the first question, second question, third question, fourth question. So these are the 4 questions that I expect you to attempt. So unless we come up with the second video on this state legislature, till then, bye bye.